in the matter of Welsh ministers versus PJ.
The clinician responsible for the treatment of a patient detained under the Mental Health Act 1983 may release him from hospital under a community treatment order. The question in this appeal is whether the clinician may impose conditions in the order which amount to depriving the patient of his liberty within the meaning of Article 5 of the European Convention on Human Rights. The patient in this case is aged 47. He has a mild learning disability and difficulties falling within the autistic spectrum. This has been accompanied by aggressive and irresponsible behaviour consisting of violent and sexual offending. In 1999, he was convicted of assault occasioning actual bodily harm and threats to kill, and the court imposed a hospital order under Section 37 of the Mental Health Act. He was discharged from a medium secure unit to a unit which later became a hospital, where he remained voluntarily as an informal patient before, in May 2009, he was compulsorily detained for treatment again, but this time under the civil power in Section 3 of the Act. In September 2011, he was discharged from hospital subject to a community treatment order, which required him to reside in a care home subject to close supervision and was only allowed out under escort or subject to strict time limits as to time, purpose and place. Before the Mental Health Review Tribunal for Wales, PJ argued that these arrangements amounted to an unlawful deprivation of his liberty, and he should therefore be discharged from the order. The tribunal held that the arrangements did not amount to a deprivation, but even if they did, the need for the order took precedence over any human rights issues. The upper tribunal held that this approach was wrong, but the Welsh ministers appealed to the Court of Appeal, where it was assumed that the arrangements did indeed amount to a deprivation. But the Court of Appeal concluded that by necessary implication, the Act allowed such conditions to be imposed. The patient now appeals to this court. At the hearing, the Welsh ministers raised a new argument. They accepted that there was no legal power to impose conditions depriving the patient of his liberty. But they argued that this meant that he was not in fact being deprived of his liberty at all, even if his actual situation was otherwise. This court holds that this does not mean that a patient has not in fact been deprived of his liberty. The whole point of habeas corpus is to secure the release of a person who is being unlawfully detained. The focus is always on his actual situation. The fact that the purpose of any deprivation involved in a community treatment order is to enhance rather than curtail the patient's freedom does not affect this assessment. However, the court agrees that there is no power to impose such conditions. There is no express power in the Act to do so. It's a fundamental principle of statutory interpretation that a power expressed in general words should not be construed so as to interfere with fundamental rights, such as the right to liberty of the person. The test for a necessary implication is also a strict one, and there is no reason to suppose that Parliament would have included such a power in the Mental Health Act had it been thought of. None of the elaborate provisions in the Act dealing with where and by whom a patient may be detained, or how he may be retaken if he escapes or goes absent without leave, apply to a community patient. There is no power to impose medical treatment on a community patient who has the capacity to consent to it and does not consent. There are no sanctions for failing to comply with the conditions in the order, although in certain circumstances a patient may be recalled to hospital and the order revoked. The purpose of the order is to release the patient into the community under arrangements which will support his continuing to receive the treatment he needs, but not to detain him in another setting. The tribunal has no power to vary or revoke the conditions. This can only be done by the responsible clinician. But the arrangements under a community treatment order may well be relevant to whether the criteria for such an order are made out, and so may be relevant to the tribunal's consideration of the case. In the light of this judgment, a conscientious, responsible clinician can be expected not to impose conditions which are not permitted in a community treatment order. And this is reinforced by the duties to provide information to a patient, and usually his nearest relative, about the effect of the order. But in the unlikely event that the conditions do lead to a deprivation of liberty on the ground, the remedy for the patient is habeas corpus or judicial review, which he can seek at any time, rather than at the limited intervals within which he can apply to a tribunal. For these reasons, the Supreme Court unanimously allows the appeal and declares that there is no power to impose conditions in a community treatment order which have the effect of depriving a patient of his liberty.